Sometimes a domestic violence situation arises from a heated verbal argument between you and your spouse. Either one of you call the police to try to calm the situation down, or it's neither of you and it's a third party such as a neighbor or someone that heard you guys arguing and they got the police involved from there. Once the police are involved, that situation is now taken out of your hands. Hi, my name's Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're talking about domestic violence second-degree charges. In South Carolina, a domestic violence second degree is a misdemeanor offense. However, even just an arrest of itself without a conviction can have serious collateral consequences to you. First, you'll have to be bonded out of jail, and then once you do get out of jail, there's going to be most likely a no contact order. And so if you live with the alleged victim in this circumstance, that means that you're not going to be able to return home. You're going to have to find another place to live up until the case is resolved either through dismissal or a conviction. So what is a domestic violence second degree? To establish domestic violence second degree, the prosecutor has to show that you caused physical harm to a household member or that you threatened to cause physical harm to a household member and put them in imminent peril. But in addition to those acts, it also covers you assaulted someone and caused moderate bodily. It also covers if you committed a domestic violence in the third degree and there is a current order of protection in place, then that will enhance the charge to domestic violence second degree. It can also be enhanced if you have a prior conviction for domestic violence within the last 10 years. Domestic violence second degree also covers acts of domestic violence third degree and the following occur. The alleged victim is pregnant, or you should have known they were pregnant. The act occurred in front of a minor child. You impeded a person's airway, basically you choked them during the assault. That person attempted to call the police using a cell phone, a phone, or some sort of electronic communication, and you interfered with that person, preventing them from doing that with the intent of stopping them from calling the police or getting medical assistance. As you can see, domestic violence in the second degree is broad and covers a number of acts that may be committed under the statute. Good defense attorneys know that it's important to meet with prosecutors to find out the basis of the state's charge, to discuss whether the alleged victim is interested in prosecuting the case anymore, and whether formal prosecution is the correct way to move forward in the case. Not all arrests end in conviction, but prosecutors and law enforcement take these cases seriously, so you need to present a defense to the prosecutors to show them that a conviction is not the only option available in your case. Some of the defenses that are available in these types of situations is if there is a lack of evidence on the case. For example, if the alleged victim is the initial aggressor in the case, then you can claim self-defense. In the situations where a cell phone is broken, one of the most common errors that are made by law enforcement is when they only have that fact alone, it's not enough to reach the level of domestic violence second degree. That statute requires that the cell phone be broken, and it was broken to prevent someone from calling police or from getting medical assistance, and that a domestic violence third assault had already occurred. So, if you've been charged with domestic violence second degree and would like to discuss your case, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.